You may remember the lawsuit against Donald Trump from several years back. He had blocked several people on Twitter. And there's an argument from many on the left that doing this violated their First Amendment rights. You see, when Donald Trump tweeted, he created a public forum for comment and criticism. And by blocking certain people on Twitter, they could not participate. Interestingly, a court agreed and told Donald Trump he had to unblock people. It also ended up backfiring on the left as AOC was then told she had to unblock people as well. Many Democrat politicians still refused to do so, and it kind of went back and forth with some saying Trump wasn't abiding by this court order, but many people suggested the ruling was bad. It would likely backfire. Because if Donald Trump was creating a public forum, then what would you call it when Twitter itself bans a conservative? Wouldn't that be denying the individual access to a public forum created by Donald Trump? How can you simultaneously have a private platform where the private corporation can ban anyone they want, but the politician couldn't? I mean, that could be as simple as the argument goes. Well, the president can't do it, but Twitter can. Well, the Supreme Court has dismissed this lawsuit at its final stage, reaching the Supreme Court, and they're saying, nah, it's moot. Donald Trump isn't the president anymore. Well, those that were suing said, then keep the lower court's ruling saying politicians cannot block people on social media. The Supreme Court said, no, the whole case fell apart. And in the end, Supreme Court Justice Clarence Thomas issued an opinion that opens the door for a lawsuit that could stop these companies from censoring conservatives. He effectively said, how is it that Twitter can just ban someone and then remove their right to speak? Maybe they should be regulated like common carriers. And that's the more conservative argument. I know that the culture war isn't always so easy to discern, factions and figure out who's on which side, but it very clearly has been the establishment Democrats and leftists saying, but my private platform. That Twitter, Facebook, YouTube, and whoever else can ban anyone they want because they're private companies. And for some reason, conservatives and liberals flipped. Now, look, it happens. But generally, we used to think that liberals were the ones in favor of regulating massive corporations. And conservatives are the ones saying, let them do their thing. And now it's not really the case. I will say, though, unsurprisingly, the Libertarian Party says it's a horrifying day for free speech, which we'll get into. But there's been a wave of good news for conservatives. At least a dozen states are introducing legislation that will stop big tech censorship. Maybe a little late to the party, but hey, we'll take what we can get when we can get it. We also have more major news in terms of I don't want to say necessarily conservatives, but victories as it pertains to the truth and the right of the individual in a lawsuit between Project Veritas and the New York Times in a court siding with Veritas. The New York Times actually admitting that their news articles are just unverifiable opinion. A tide is changing in the culture war with these rulings, and we could be facing something profound. If someone picks up on Clarence Thomas's opinion that these big tech companies perhaps should be regulated, we might actually see something. Now, first, it would likely have to go through the courts at this point because Democrats control basically everything else. And there could theoretically be legislation that changes this, but there could be activist judges that legislate from the bench. There's already been an attempt to redefine Section 230 or to clarify Section 230, which grants immunity to these platforms by having the FCC do it. In the end, it seems it will take an act of Congress. And that seems to be what Clarence Thomas is saying. But based on his opinion, there could be a lawsuit that makes it to the court. And if it makes it to the Supreme Court, then they can rule you cannot ban people based on political opinions. More importantly, it may not happen at the federal level, but it very well may happen at the state level, as several states, including Texas and Florida, are seeking to ban arbitrary censorship. Well, let's read exactly what's going on. But before we do, head over to timcast.com and become members, my friends, because censorship is a very real issue. My Facebook page has already effectively ended because they didn't like that I was covering what happened in the news in one particular day. And many people think that I'm immune to what's going on. It's only a matter of time. Become a member at timcast.com to help support my work and get access to exclusive members-only segments from the Timcast IRL podcast. The new website will be launching soon, and we're going to be doing a whole bunch of other content, new shows, new podcasts, new personalities. We're going to be growing and expanding and producing culture outside of these pigeonholes that are produced by big tech social media, basically forcing everyone to adhere to particular opinions. We're going to challenge that. And in the event that I do get suspended or banned or removed or whatever, you'll be able to find me at timcast.com. So also, don't forget to like, share, subscribe, hit that notification bell. Let's read this news. NBC News says Supreme Court dismisses lawsuit over Trump's Twitter account. They report the Supreme Court on Monday tossed out a lawsuit over former President Donald Trump's Twitter account after the Justice Department said the end of Trump's presidency made the case a dead letter. The case arose after 7 people responded critically to tweets on the president's now banned real Donald Trump account, and he retaliated by blocking them. They sued and won in the lower courts, which held that blocking individual respondents based on their viewpoints violated the First Amendment. The Court of Appeals for the Second Circuit said the president's account amounted to a kind of public forum and often concerned official matters with contributions from White House staff members. The Trump Justice Department urged the Supreme Court to reverse those rulings. While the president's tweets were sometimes official statements, his decision to block individual responses was a personal one allowed by any Twitter user, government lawyers contended. But the night before President Joe Biden took the oath of office, the Justice Department asked the court to dismiss the case as moot and vacate the lower court rulings as well. Katie Fallow of the Knight Institute, a group that advocates on behalf of First Amendment issues and represented the Twitter users who Trump blocked, urged the justices to leave the lower court rulings intact. There is now widespread recognition that the principles we established in this case are important to protecting the vitality of public forums that are increasingly important to our democracy, shaping the way public officials use social media. Justice Clarence Thomas said he agreed that the case should be dismissed as moot, but he said that it highlighted a problem, namely that applying old doctrines to new digital platforms is rarely straightforward. It seems odd, Thomas said, to say that something is a government forum when a private company has unrestricted authority to do away with it. Interesting. Well, the Supreme Court has in fact vacated that ruling, which prevented Trump from blocking Twitter critics in a major defeat for these leftists. Now, I wouldn't say this is necessarily a good thing. There's an interesting argument about whether or not it is a public forum. I certainly think there is a good argument. It is. And hear me out. Donald Trump was the president. He bypassed the press when he gave these statements. I like this. But you have to recognize that people are allowed to criticize and have free speech. If the platform allows it, Trump should not be removing people, and I want to see these arguments and these conversations. The bigger problem, however, is then the argument that Twitter is a private platform. Strange to me that many leftists were saying Twitter is a private platform, they can do what they want. But it's also a public forum where Trump can't ban people. You can't have your cake and eat it too, because after you eat it, it's gone, okay? So if you make that move where you're saying it's a private company, but then you join in a lawsuit or you cheer on the lawsuit where you're saying Trump shouldn't be able to ban people, congratulations. I agree. It's a public forum. Therefore, Twitter can't ban people. Here's the way I describe it. When this happened, when all this was going down, I said, imagine that there's a big open field and a private company sets up fencing around this land and they own the land. And Donald Trump shows up one day and starts speaking there. You show up and you walk in, say, I want to hear what the president has to say. Then one day they decide you can't come in anymore. And you're like, but this is my president. You have the entire town square. You've bought it and no one's going anywhere else. And they say, oh, there's alternatives. There's there's other social media platforms competing. The way I described it was like, imagine there's the LA Coliseum, this massive stadium in Los Angeles. And Donald Trump announces he's going to be giving a State of the Union address just there. That's the only place. But you're banned from the Coliseum. They say you're more than welcome to go use the soccer field down at the local high school. And you're like, yeah, okay, I can go there, but the president isn't speaking there. I think that there are certain limitations, in my opinion. Now, in the real world, does this mean the LA Coliseum has to let everybody in if they're having a private event with Trump? No. The issue is that there is nowhere else to go. There is nowhere to have a meaningful conversation in response to the president's posts or talk to the president because he wasn't using any of those places. We are seeing massive multinational corporations monopolize public discourse. Libertarians certainly disagree with me, big L libertarian, by the way, where they say it's bad for free speech. Look, I understand there's complicated questions here, but Twitter is not beholden to the American people. They're beholden to an international body of investors. Jack Dorsey even said their rules are designed for a global audience. Well, when it's matters of U.S. public interest, why should we allow Russians to use Twitter to influence Americans, but American citizens have been banned? You see the problem there. You want to talk about private platforms? Sure, but there's got to be some rules at some point. Look, you don't allow people to go and sell snake oil. We have restrictions on what you can buy or trade. Not all of it's perfect. Not all of it is good. But when there's basically one place where the president is speaking where everyone's at, you have very, very real problems. Now, the president, of course, could have gone to a different platform, and he didn't. And that's actually the best counter argument. It was the president's fault himself. He could have gone to the local high school football field and talked to his constituents. He didn't do it. So then is it really the Twitter's fault that Trump uses their platform and no one else's? Not necessarily. The bigger issue at play, though, is the coordination between big tech to take out their competition, in which case now it's time to bring on antitrust and regulation. When Parler started to compete with Twitter, what happened? Seemingly all of these companies reacted at the exact same time. The Play Store, Google, they remove Google's App Store and the Play Store and the iPhone App Store. They banned Parler. They all started making claims about Parler. It seemed very much coordinated, and we know it wasn't true. The Wall Street Journal reported that Parler was reporting the users on its platform who were, talking about violence. Facebook, on the other hand, has been accused relentlessly, and over again, we hear stories about the evil people who use Facebook. I mean, like serious gang activity and really awful stuff. But no one takes action against Facebook. The app is allowed to be on iTunes, to be on the App Store, and to be in Google. So it seems coordinated. So you want to argue that Twitter is a private platform, sure. But in concert, all of these social media networks are banning the same people, shutting down the same services, and restricting access. And they're all located very, very close to one another. It's likely most of them know each other, and they are doing this to stifle any competition to their monopolies. It's not that they have a single strong monopoly. They have a network of digital assets and tools they control and don't allow competition in. So you want to do that, break them up and shatter that? Okay, fine. Then I'll be okay with you saying, but my private platform. In the meantime, I think people need to be able to see the president speak and respond to the president's posts. Yahoo Finance reports the Supreme Court has vacated a ruling that prevented former President Donald Trump from blocking people. After Trump lost his bid, they said it was moot. The ruling won't matter much to Trump, however, because he was permanently banned. So there we go. The lower court decision had implications for other elected officials and how they communicate on social networks. The public interest in preventing impermissible viewpoint discrimination in government-operated social media accounts weighs heavily in favor of keeping the Second Circuit's judgment in place, the Knight First Amendment Institute at Columbia University, which sued Trump, wrote in a brief. The institute agreed that the ruling was moot, but instead claimed that it was because of Trump's Twitter ban. This is actually true, but it shows how kind of stupid the courts can be. The case is moot, meaning, well, Trump's not the president anymore and you're suing Trump, so he's no longer a party to the lawsuit. That's true. But isn't it dumb that we're really talking about a much bigger issue about other politicians, but the way the court is set up, we're going to be like, nah, you can throw this one out because this one guy isn't president anymore. AOC should be party to this lawsuit. Sue her. She blocks people. Ultimately, I don't like the idea that they can block people, but we need to talk about what this really means in the long term. Are we going to create a new rule set for digital tools in today's era, or are we going to just let them run amok? Sorry, I think we need regulation. We regulated the phone companies, common carriers. They can't have viewpoint discrimination. Maybe it's time to do the same thing. This is where Clarence Thomas steps in and opens the door for potentially a lawsuit which could end the censorship. The Examiner reports Clarence Thomas wins approval from populists for suggesting Twitter regulation. Justice Clarence Thomas won praise. We see this. Great, tweeted author J.D. Vance, who is eyeing an Ohio Senate run. Thomas's opinion, a concurrence in a case concerning former President Trump's Twitter usage, took issue with the way that Twitter, Facebook, and other social media companies handle speech on their platforms. While Thomas agreed with the rest of the court that questions about Trump's Twitter usage are moot, he stressed that in the near future, the court must address social media regulation. Thomas focused on Twitter's ban of Trump, arguing that the move raised the stakes for Twitter to prove that it is a public platform. Thomas noted that Trump faced a lawsuit after he blocked a few people using his Twitter account because the platform is generally understood as a public forum. But at the same time, he added, Twitter was able to remove Trump from its platform, which amounted to a block barring all Twitter users from interacting with his message. If it is a violation of someone's First Amendment rights to block them from communicating with the president on his posts in a public forum, then why should Twitter be allowed to do it? Is the question that only Trump can't block people? Okay, then, if that were the case, that would mean The president could create a public forum and then hire private security who at their own discretion could remove people from that forum and argue, well, private security, they're not an agent of the government, so they're allowed to do it. Twitter makes money off of Donald Trump's presence on the platform. Trump simply using the space should not mean that private security guards would be able to remove people when Trump is there. You see my point? You're basically saying the government can just pass off the censorship to a corporation, even though we know why it's happening and that it's okay. Trump used Twitter's technology to suppress people's First Amendment rights. You're saying that so long as Trump just says, I wish, won't someone rid me of this priest, that Twitter is then allowed to do it? You see what I'm saying? They say Twitter's user agreement permits it to remove users, but the Trump case highlights how such arrangements become difficult to navigate if the platform is truly a public forum, Thomas wrote. He suggested that if part of the problem is private concentrated control over online content and platforms available to the public, then a possible solution is doctrines that limit the right of a private company to exclude figures such as Trump. Thomas took a more broad aim at technology companies, saying that they act as gatekeepers over the internet, which leads to speech suppression. The suggestion that the federal government should treat platforms such as Twitter and Facebook as quasi-public utilities, long a goal of left-wing social critics, won popularity with insurgent populists, many of whom have raised new concerns about online speech regulation. Missouri Senator Josh Hawley cited Thomas's observation that Google facilitates 90% of internet searches, which Thomas said allows it to suppress content by de-indexing or downlisting a search result or by steering users away from certain content. Hawley, who has championed social media regulation, tweeted that Thomas was warning about the dangers of big tech concentration for free speech. The case, Knight First Amendment Institute versus Trump, arose in 2017, so this we entirely understand. Over on Twitter, Mark Joseph Stern, he is a staff writer at Slate, said, in other words, Clarence Thomas is inviting Congress to ban social media companies from engaging in content moderation by stripping them of their own First Amendment rights and transforming them for legal purposes into common carriers or public accommodation. He says, you know, the conservatives who have been arguing unsuccessfully so far that social media companies are so powerful that Congress can essentially override their own First Amendment rights and force them to host certain speech on their platform. Thomas just endorsed that argument. I absolutely love the sheer absurdity of what we are seeing here. The Libertarian Party on Twitter basically said it's terrible for free speech. And somehow you have the leftists arguing against the government seizing the means of production. So you have the Libertarian Party of Texas, mind you. They come out on Twitter and they say, Thomas just ruled that the government can seize the means of social media production to protect the First Amendment. And I'm like, sure, fine. I don't care. That's a ridiculous argument, by the way. They're regulating them as we do many companies. And now you have Slate, which is a leftist publication, saying that the government shouldn't seize the what a stupid world we live in. Let me break it down for you very simply. The left benefits from their political allies at big tech censoring opinions they do not like. So it doesn't matter what their principles are supposed to be. They don't have any. All they want is power. The Libertarian Party are more than happy to welcome being crushed by massive multinational corporations so long as it isn't the government doing it. That's absurd. We either break these companies up or we recognize social media is playing a primary role in how politics are being shaped in this country. While Democrats overwhelmingly get their news from mainstream news channels on TV and the internet, conservatives get their information from a decentralized network of independent personalities and smaller news companies, and then Fox News. So as these big tech companies begin banning conservative voices and opinion, they are funneling all opinions towards the mainstream media that conservatives and Republicans don't trust as it is, and most moderates don't either. If this big tech, what's the right word for it? It's not necessarily like one company in a monopoly. It's more like it's collusion. It's a bunch of companies with similar interests protecting the interests of each other and suppressing the rights of those who have opinions they don't like. So the left, who don't have opinions, support this. Of course they do. They're winning. It's their friends and allies at the top level of big tech who are banning people. My favorite part is how they say, it's not true, there's no conservative censorship. And it's literally Gizmodo that broke the story in May 2018 that Facebook was literally removing conservative news websites. Where did that go? It's no surprise that Democrats overwhelmingly just trust the mainstream media. But it is a good day for those who believe in free speech on the internet. The libertarians might say, it's terrible for the free speech of these massive multinational corporations. Forgive me. If I have to make a choice between a single massive multinational corporation and 330 million individuals who have a right to an opinion, if you build a platform, there are certain things that are allowed in terms of regulation. Put it this way. I think that if you run like a Christian blog and there's a comment section and you have rules and someone comes in and starts posting things that are very offensive to your readers and there's a purpose to your site, within reason, it is okay to ban people for opinions you don't like. It probably has more to do with the size of the company. Now, it could just be that Section 230 must be reformed outright to say, here are certain things that can be removed and can't be removed. But ultimately, if we're talking about social media companies, perhaps the real regulation needs to be a news publication or a blog that produces content and has a comment section shall be separate from social media platforms designed with the express purpose of allowing individuals to post. Perhaps the real problem here is acting like Twitter is the same thing as the comment sections on a blog. And this is where it all began. My understanding is that Section 230 of the Communications Decency Act came about because someone posted something disparaging in the comment section of a newspaper, of a news website. Someone sued and they said, well, you can't sue the newspaper for the comment of a user. So they said, okay, how about third-party posts don't represent the entirety of the paper, so you got to go after the individual instead. Then social media websites came about. Now listen, if there's a website called timcast.com, okay, my website, and someone goes to the comment section in the member section and says something libelous, it makes sense that you can't sue me. It's just a user's comment. My website was not designed specifically for people to come and post their media. It's for them to comment on my media. That I understand. Now, what if someone makes a website where they're specifically saying, we don't actually post anything. It's for you guys to post and share content. It's not the same thing. And therein lies the problem. Treating Twitter like a blog. It's not. The purpose of Twitter is for individuals to post their opinions and news articles and share information. Stop treating Twitter, Facebook, and YouTube the same as some small website. It doesn't even have anything to do with users. It should specifically be, if you create a website called ChristianTwitter.com, and you say it's for Christians to share their values, but you tell people they are the ones posting and we're standing back, perhaps then you are not protected by Section 230. And what they need to do is define in Section 230 what they mean by online platforms. Because when you are talking about blogs, and when this law was created, nobody is referencing social media. It's totally different. Now, Twitter makes statements. I've often talked about when Twitter makes a statement, when Facebook does. For instance, if I make an article and I put it on Facebook, Facebook then empowers very specific people to defame me. More importantly, if one of these fact checkers says I lied, they can then put a label on my post saying false or, incorrect information. Facebook is doing that. Facebook is implementing the filter. Facebook made the statement. Now they say third-party fact checkers said this. But at a certain point, we have to ask ourselves, in that instance, these people are commissioned by Facebook to do this. So Facebook certainly has some responsibility here, don't they? Perhaps. The reality is it is not all the same thing. And the problem is that Section 230, which is allowing conservatives for the most part to be censored, and many progressives are getting censored as well, is being used as a blanket over anything on the internet. So Clarence Thomas made a good point. He said, are we going to be treating, all of these things based on archaic policy, or do we make new ones? We make new ones. Perhaps it's time to specify that Section 230 does not pertain to common carriers, and perhaps it's time to specify that Twitter and Facebook and YouTube and big tech social media companies that are designed to allow individuals to speak are more akin to a phone company than they are to a blog. Well, here we go, baby. GOP pushes bills to allow social media censorship lawsuits. It's a coming. The AP reports Republican state lawmakers are pushing for social media giants to face costly lawsuits for policing content on their websites, taking aim at a federal law that prevents internet companies from being sued for removing posts. GOP politicians in roughly 24 states have introduced bills that would allow for civil lawsuits against platforms for what they call the censorship of posts. Many protest the deletion of political and religious statements, according to the National Conference of State Legislatures. Democrats, who also have called for greater scrutiny of big tech, are sponsoring the same measures in at least 2 states. Here we go. The federal liability shield has long been a target of former President Donald Trump and other Republicans, whose complaints about Silicon Valley stifling conservative viewpoints were amplified when the companies cracked down on misleading posts about the 2020 election. We're going to stop right there. And I'm going to tell you why the next big move, next big victory is Project Veritas's victory. You see what they did there? Taking down misleading posts. That's how the media launders lies. That's how they lie to you. And it's clever, but it won't work forever. And Project Veritas's victory shows this. Let me break this down for you and help you navigate the media. They say Democrats, who have also called for greater scrutiny, blah, blah, blah. The federal liability shield has long been a target of President Trump and other Republicans whose complaints about Silicon Valley stifling conservative viewpoints were amplified when the companies cracked down on misleading posts about the 2020 election. They stated, as a matter of fact, that companies cracked down on misleading posts. Twitter censored news about Hunter Biden, Joe Biden's son, that were true, but they say misleading post. That is a false statement of fact. But there's no one who really has standing. I suppose Trump could claim that's fake news and argue that their real concern was the censoring of information, period. This is how the media lies. I'll give you a great real world example. No, I'm sorry. I'll get to avoid litigation, because it's a very real circumstance to speaking out in these spaces. I'll give you a hypothetical based on a real world example. Let's say you decide to do a YouTube video or Twitter. You make a Twitter post. In your Twitter video, you are talking about how much you just love Easter Sunday. Now, Easter just came and you love coloring the eggs. And in your video, you happen to be using a particular brand of Easter egg dyes and coloring kits. Well, some leftist activists sees you making this video, and they then send an angry email to the company saying, why is there a prominent video with the far right, racist, whatever, using your product? Now, the video you posted has nothing to do with race. It's about Easter eggs. The company then comes out and says, we recently learned that an individual, named so-and-so was using our dyeing kit. We do not endorse their racist views, their blah, blah, blah. We strongly condemn any and all bigotry and have nothing to do with this video. What happens is, because they want to distance themselves, it doesn't matter if you actually said it. They're not accusing you of having said it. They just say, we denounce their racist views or anything racist they may have done. Then the media steps in and says, individual has been denounced by Easter Egg Company over racist, bigoted views. The average person assumes you actually said it. You didn't. It's how the media launders these statements. They're lies. They're not real, and they get away with it. Right now, they're saying misleading posts. Well, the good news is the states are coming in. They're starting to intervene. They're starting to say no to this stuff. The bad news is the media just keeps lying, which brings me to the next massive and major victory in the whole circumstance. I give you, from the Washington Examiner, the New York Times' embarrassing defense in the Project Veritas case, where they state, early arguments in the case included remarkable exchanges between New York Times lawyers, Project Veritas lawyers, and Judge Wood. But from the standpoint of leaders interested in the state of journalism today, perhaps the most remarkable was the outlet's defense that Aster and Sue, both of the reporters being sued here, freely injected opinion into their reports, even though the stories were published in the news section of the paper, the New York Times argued. Project Veritas was not entitled to sue for libel because the opinions expressed were unverifiable, saying, unverifiable expressions of opinion are not actionable and cannot be defamatory. The paper argued in its motion to dismiss the case. A defamation action must be based on statements of objective fact, not on an expression of opinion, which by definition cannot be true or false. In this politically charged context, the term deceptive is not susceptible to an objective meaning and is therefore a non-actionable opinion. That's amazing. As Mike Cernovich put it, he says, check this out from the judge's opinion. If a writer interjects an opinion in a news article and will seek to claim legal protections as opinion, it stands to reason the writer should have an obligation to alert the reader. My friends, the New York Times has stated in their legal defense, their news section regularly has, or at least in this instance had, unverifiable opinions, and therefore they can't be sued. Well, here we go. These are all major victories for moderates and those challenging the establishment media's lies. You still can't get around the tricks. They'll say, well, Twitter did ban misleading information. We didn't say it was the only thing they banned. And conservatives were concerned. No, conservatives aren't concerned about the banning of misleading information. Conservatives actually want the misleading information to be stopped. Conservatives are concerned because those that are fact-checking and challenging and criticizing are being banned. That's the AP putting out fake news. It's amazing how this all comes together. In the end, Clarence Thomas has opened the door. No, actually, I should say, the leftists who sued Donald Trump opened the door for the Supreme Court to put out their opinion, and Clarence Thomas has a very strong one. It is just a crack in the door. We don't know where this will lead, and maybe it'll lead to nothing. But Clarence Thomas brings up very important points, and we may actually see at the state level censorship finally put to rest. If the Republicans don't get on top of this now, they'll certainly lose 2022 and 2024. Each and every day, conservative opinion is being eroded, and more conservatives adopt progressive viewpoints in order to stay alive, figuratively, on social media. There are even some conservatives who have changed their opinions and now claim to be liberal because they were scared about getting banned off YouTube. It happens. So if they don't stand up, it won't matter. But for them, in the meantime, it looks like conservatives are getting major victories. And, well, it's about time, I suppose. I'll leave it there. Next segment's coming up tonight at 8 p.m. over at youtube.com/TimcastIRL. It's a live show. So subscribe to youtube.com/TimcastIRL. Go to timcast.com, and we will see you all at 8 p.m. tonight. Thanks for hanging out.